Hello at magandang hapon. At sana po sa mga kababayan ko rito sa Pilipinas, sana lagi tayong safe sa pagdaan ni Bagyong Rolly. At ayun lang, maghahati na naman ako ng isa na namang edisyon ng in layman's term, wherein susubukan nating basahin ang criminal procedure at susubukan natin itong ipaliwanag ng konti sa abot lamang na ating makakaya. Pero basically, babasahin ko lamang siya para sa inyo. Para sa inyong online reference ng criminal procedure. Last time, nagtapos po tayo sa Rule 110 hanggang 115. Yun po kasi ang simula ng criminal procedure sa librong Rules of Court. So ngayon, magbabasahin naman natin yung 116 and hopefully matapos natin hanggang sa 121. Start na tayo. Rule 116. Arraignment and plea. Paano ba ginagawa ang arraignment at ang paglalatag ng iyong plea? Letter A. The accused must be arraigned before the court where the complaint or information was filed or assigned for trial. The arraignment shall be made in open court by the judge or clerk by furnishing the accused with a copy of the complaint or information, reading the same in the language or dialect known to him, and asking him whether he pleads guilty or not guilty. The prosecution may call at the trial witnesses other than those named in the complaint or information. Letter B. So yun po ha. Ito yung proseso sa korte kung saan inihaharap sa korte ang akusado at ibinabasa sa kanya yung akusasyon lamang sa kanya, at sa harapan ng korte ipapasok niya or he or she may enter yung kanyang plea o yung kanyang pagsusumamo. Tama ba yung term ko? Na siya ay inaamin niya ba ang kasalanan o hindi. Letter B. The accused must be present at the arraignment and must personally enter his plea. Both arraignment and plea shall be made of record, but failure to do so shall not affect the validity of the proceedings. Letter C. When the accused refuses to plead or makes a conditional plea, a plea of not guilty shall be entered for him. So kung yung akusado raw, conditional plea yung kanyang ipinasok, not guilty ang plea na i-enter para sa kanya. Letter D. When the accused pleads guilty but presents exculpatory evidence, his plea shall be deemed withdrawn and the plea of not guilty shall be entered for him. Ibig sabihin, nagpresenta siya ng guilty siya pero nagpresenta siya ng ebidensya na maaaring makatulong sa kanya, pabor sa kanya. Yun ang i-enter na plea para sa kanya. Letter E. When the accused is under preventive detention, his case shall be raffled and its records transmitted to the judge to whom the case was raffled within 3 days from the filing of the information or complaint. The accused shall be arraigned within 10 days from the date of the raffle. The pre-trial conference of his case shall be held within 10 days after arraignment. Letter F. The private offended party, ito po yung biktima, yung partido ng biktima, shall be required to appear at the arraignment for purposes of plea bargaining, determination of civil liability, and other matters requiring his presence. In case of failure of the offended party to appear despite due notice, the court may allow the accused to enter a plea of guilty to a lesser offense which is necessarily included in the offense charged with the conformity of the trial prosecutor alone. So kapag daw yung partidos ng isang biktima ay hindi nag-attend, pwedeng payagan ng hukuman na mag-enter ng plea of guilty sa isang guilty to a lesser offense na sigurado naman daw na kasama or included sa charge o dun sa kasong isinampa sa kanya, alinsunod doon sa prosecutor, doon sa nais ng prosecutor o yung isinaad ng prosecutor. Letter G. Unless a shorter period is provided by special law or Supreme Court circular, the arraignment shall be held within 30 days from the date the court acquires jurisdiction over the person of the accused. The time of the pendency of a motion to quash or for a bill of particulars or other causes justifying suspension of the arraignment shall be excluded in the computing the period. Kasi mayroon pong mga pwedeng during the pendency of motion to quash. Kunwari, nag-file yung depensa ng motion to quash the information dahil sa kadahilan ng maaring walang saysay yung information laban dun sa akusado, or yung mga sabi nila meron daw at the time of the pendency of motion to quash or for a bill of particulars or other causes justifying suspension of the arraignment shall be excluded in computing the period. So to those who are trying to listen here, you may also learn because I'm just reading and trying to explain the laws of the Philippines. Now we are discussing about the criminal procedure. Section 2. Plea of guilty to a lesser offense. At arraignment, the accused, with the consent of the offended party and the prosecutor, may be allowed by the trial court to plead guilty to a lesser offense, which is necessarily included in the offense charged, period. After arraignment, but before trial, the accused may still be allowed to plead guilty to said lesser offense after withdrawing his plea of not guilty. No amendment of the complaint or information is necessary. Magtungo naman tayo sa Section 3. Plea of guilty to capital offense. Yung pagtanggap or yung reception of evidence. When the accused pleads guilty to a capital offense, the court shall conduct a searching inquiry into the voluntariness and full comprehension of the consequences of his plea and require the prosecution to prove his guilt and the precise degree of culpability o yung degree ng kanyang pagkakasala. The accused may present evidence in his behalf. Section 4, plea of guilty to non-capital offense at yung pagtanggap ng ebidensya. Yung non-capital, ibig sabihin hindi naman ganun kabigat na opensa o kaparusahan para sa krimen na inakusa. When the accused pleads guilty to a non-capital offense, the court may receive evidence from the parties to determine the penalty to be imposed. Section 5, withdrawal of improvident plea of guilty. At any time before the judgment of conviction, ulitin ko, at any time before the judgment of conviction becomes final, the court may permit an improvident plea of guilty to be withdrawn and be substituted by a plea of not guilty. Section 6. Duty of court to inform accused of his right to counsel. Before arraignment, the court shall inform the accused of his right o yung karapatan niya to counsel and ask him if he desires to have one. Unless the accused is allowed to defend himself in person or has employed the counsel of his choice, yung may sarili siyang abogado, the court must assign a counsel de officio to defend him. Section 7, appointment of counsel de officio. Usually, sa tunay na buhay, public attorneys ang ina-assign ng court dito. The court, considering the gravity of the offense and the difficulty of the questions that may arise, shall appoint as counsel de officio only such members of the bar in good standing who, by reason of their experience and ability, can competently defend the accused. But in localities where such members of the bar are not available, the court may appoint any person resident of the province and of good repute for probity and ability to defend the accused. Section 8. Time for counsel de officio to prepare for arraignment. Whenever a counsel de officio is appointed by the court to defend the accused at the arraignment, he shall be given a reasonable time to consult with the accused as to his plea before proceeding with the arraignment. Section 9. Tungo tayo sa Bill of Particulars. Meron ding Bill of Particulars para sa civil cases. Ito naman sa criminal cases. The accused may, before arraignment, move for a Bill of Particulars to enable him properly to plead and to prepare for trial. The motion shall specify the alleged defects of the complaint or information and the details desired. So bago iharap ang isang akusado to enter his plea of guilty or not guilty, pwede siyang mag-move o yung kanyang counsel, yung partidos niya ng Bill of Particulars para kung hindi naman malinaw yung akusasyon na ibinabato sa kanya. Section 10, production or inspection of material evidence in possession of prosecution. Upon motion of the accused showing good cause and with notice to the parties, the court, in order to prevent surprise, suppression, or alteration, may order the prosecution to produce and permit the inspection and copying of or photographing, pipicturan, of any written statement given by the complainant and other witnesses in any investigation of the offense conducted by the prosecutor or other investigating officers, as well as any designated documents, papers, books, accounts, letters, photographs, objects, or tangible things not otherwise privileged, which constitute or contain evidence material to any matter involved in the case and which are in the possession or under the control of the prosecution, police, or other law investigating agencies. Section 11, yung suspension of arraignment. Upon motion by the proper party, the arraignment shall be suspended in the following cases. Letter A. The accused appears to be suffering from an unsound mental condition, which effective renders him unable to fully understand the charge against him and to plead intelligently thereto. In such case, the court shall order his mental examination and, if necessary, his confinement for such purpose. Yung akusado na baliw o nagkaroon ng problema sa pag-iisip at hindi niya properly na maiintindihan yung inaakusa sa kanya, pwedeng masuspend yung arraignment. Letter B. There exists a prejudicial question. And letter C. A petition for review of the resolution of the prosecutor is pending at either the Department of Justice or the Office of the President, provided that the period of suspension shall not exceed 60 days counted from the filing of the petition with the reviewing office. Okay. Banggit natin last time na pwedeng umapila at the prosecutor's level pa lang hanggang sa DOJ. In this case, nabanggit niya rin ang Office of the President. Rule 119, motion to quash. At any time daw, before entering his plea, o sabihin na natin before arraignment, the accused may move to quash the complaint or information. Ito yung form and contents. The motion to quash shall be in writing, signed by the accused or his counsel, and shall distinctly specify its factual and legal grounds. The court shall consider no ground other than those stated in the motion, except lack of jurisdiction over the offense charged. Okay. So yun lang ang pwedeng i-grant ng court, yung lack of jurisdiction over the offense charged, para ma-quash mo yung information. Walang ibig sabihin walang jurisdiction yung korte para dinggin yung kaso. Yun ang ibig sabihin ng Section 3. Yun lang ang ground, sabi. Pero ayon dito sa Section 3, yung grounds, the accused may move to quash the complaint or information on any of the following grounds. Ito pala yung listahan ng grounds. Letter A, the facts charged do not constitute an offense. Sinampan mo siya ng kaso pero wala namang krimen pala doon sa inaakusa mo sa kanya. Letter B, that the court trying the case has no jurisdiction over the offense charged. Ayan. Sinabi natin yan. Letter C, that the court trying the case has no jurisdiction over the person of the accused. Wala pa sa jurisdiction ng korte yung akusado. Ibig sabihin, hindi pa nahuhuli. Maaaring hindi natin kilala. Letter D, that the officer who filed the information had no authority to do so. Letter E, that it does not conform substantially to the prescribed form. Letter F, that more than one offense is charged, except when a single punishment for various offenses is prescribed by law. Letter G, that the criminal action or liability has been extinguished. Letter H, that it contains averments which, if true, would constitute a legal excuse or justification. And letter I, that the accused has been previously convicted or acquitted of the offense charged, or the case against him was dismissed or otherwise terminated without his express consent. Malinaw naman po yung mga sinabi roon. Section 4, amendment of the complaint or information. If the motion to quash is based on an alleged defect of the complaint or information which can be cured by amendment, ibig sabihin may depekto yung nakasaad sa impormasyon na nag-aakusa laban sa akusado, pero pwede naman itong lunasan sa pamamagitan ng pag-aamenda. The court shall order that an amendment be made. If it is based on the ground that the facts charged do not constitute an offense, the prosecution shall be given by the court an opportunity to correct the defect by amendment. The motion shall be granted if the prosecution fails to make the amendment or the complaint or information still suffers from the same defect despite the amendment. Section 5. Effect of sustaining the motion to quash. If the motion to quash is sustained, the court may order that another complaint or information be filed except as provided in Section 6 of this rule. If the order is made, the accused, if in custody, shall not be discharged unless admitted to bail. If no order is made, or if having been made, no new information is filed within the time specified in the order, or within such further time as the court may allow for good cause, the accused, if in custody, shall be discharged unless he is also in custody for another charge. Section 6. Order sustaining the motion to quash not a bar to another prosecution. At yung exception. An order sustaining the motion to quash is not a bar to another prosecution for the same offense unless the motion was based on the grounds specified in Rule 3G and I of this rule. Yun nga, yung walang jurisdiction. Yung korte, unless ganon. Yung pagsusustain daw ng motion to quash is not a bar o hindi siya harang para sa another prosecution for the same offense. Yun nga, unless walang jurisdiction yung korte at yung iba pang nabanggit natin na grounds sa nagdaan nating binasa. Section 7. Former conviction or acquittal, double jeopardy. Ito, nakaangkla na naman sa konstitusyon ito. When an accused has been convicted or acquitted, or the case against him is dismissed or otherwise terminated without his express consent by a court of competent jurisdiction, upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused had pleaded to the charge, the conviction or acquittal of the accused or the dismissed of the case shall be a bar to another prosecution. Ibig sabihin, hindi mo na siya pwedeng i-prosecute muli for the offense charged or for any attempt to commit the same or frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charged in the former complaint or information. Kasi nga, lalabag ka na sa double jeopardy pag ginawa mo yan. However, the conviction of the accused shall not be a bar to another prosecution for an offense which necessarily includes the offense charged in the former complaint or information under any of the following circumstances. Letter A. The graver offense developed due to supervening effects arising from the same act or omission constituting the former charge. Ang mas malalang krimen ang na-develop dahil sa mga ibang mga pangyayari arising from the same act or omission. Kunwari, binugbog mo na ospital. Ang kaso mo lamang doon, kunwari, ay either serious or slight or less physical injuries ay namatay. So, tataas na yung krimen na pwedeng i-charge sa'yo. Letter B. The facts constituting the graver charge became known or were discovered only after a plea was entered in the former complaint or information. May bagong facts. Letter C. The plea of guilty to the lesser offense was made without the consent o walang pahintulot ng prosecutor and of the offended party except as provided in Section 1F of Rule 116. If any of the foregoing cases where the accused satisfies or serves in whole or in part the judgment, he shall be credited with the same in the event of conviction for the graver offense. Section 8. Provisional dismissal. A case shall not be provisionally dismissed except with the express consent of the accused and with notice to the offended party. The provisional dismissal of offenses punishable by imprisonment not exceeding 6 years or a fine of any amount or both shall become permanent 1 year after issuance of the order without the case having been revived. With respect to offenses punishable by imprisonment of more than 6 years, their provisional dismissal shall become permanent 2 years after issuance of the order without the case having been revived. Okay? Okay. Sandali lang, bago natin ituloy, bakit hindi natin basahin yung kahulugan ng provisional dismissal para lang makumpleto kahit papaano yung ating pag-aaral? Ano ba yan? Sandali. May ibig sabihin itong provisional dismissal. Basahin lang natin. Wait lang, loading. Wait, eto. A case shall not be sandali. Parang hindi niya naman pinaliwanag ano yung provisional dismissal. Parang inulit niya lang yung binabasa ko. Sandali, hanap tayo nung eksaktong definition niya lang para lang maano natin. Sandali. Ayan o. A case shall not be provisionally, parang ganun din inulit lang pero a case shall not be provisionally dismissed except with the express consent of the accused and with notice to the offended party. So yun ang ibig sabihin ng provisional dismissal kasi ilang beses na natin binabasa yung without the consent of the consent of the accused. Yung provisional dismissal is with the express consent of the accused and with notice to the offended party. The provisional dismissal of the offense is punishable by imprisonment not exceeding 6 years or a fine of any amount or both shall become permanent 1 year after the issuance of the order without the case having been revived. So, provisionally dismissed siya. Kapag hindi na-revive yung kaso na yon. With respect naman daw to offenses punishable by imprisonment, ito yung binabasa natin kanina, their provisional dismissal shall become permanent 2 years after issuance of the order. So, sa madaling salita, ang provisional dismissal is na-dismiss yung kaso with the express consent of the accused with notice to the parties, to the other party. Okay? Yan lang ang ibig sabihin ng provisional dismissal. Diba? Dismissed provisionally. Magtungo naman tayo sa Rule 118 pre-trial. Di ba, nung nagbabasa tayo dun sa Rules on Civil Procedure, Civil Cases, merong pre-trial. Meron ding pre-trial sa Criminal Procedure. Sabi rito, mandatory ang pre-trial in criminal cases. In all cases cognizable by the Sandigan Bayan, Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court and Municipal Circuit Trial Court, the court shall after arraignment, matapos yung arraignment, pinag-uusapan nating pag-e-enter ng plea, and within 30 days from the date the court acquires jurisdiction over the person of the accused, unless a shorter period is provided for in special laws or circulars of the Supreme Court, order a pre-trial conference to consider the following. Ito yun. Plea bargaining, stipulation of facts, letter C, marking for identification of evidence of the parties. Ganon din, similar dun sa civil cases. Waiver of objections to admissibility of evidence. Letter E, modification of the order of trial if the accused admits the charge but interposes a lawful defense. Letter F, such other matters as will promote a fair and expeditious o mas mabilis na trial at the criminal and civil aspects of the case. Pero ito, mga abogado lang yung normal na nagdaan sa pag-aaral nito, pero subukan lang din nating daanan para maintindihan natin. Plea bargaining, nakikipagkasundo ka kung ano, di ba nag-enter ka na ng plea. So pwede ka pang makipag-bargain daw. Di ba? After ng arraignment nito, before pa yung mismong trial. Pag sinabi nating trial, yung alam natin in layman's term, yung nagpipresenta na ng ebidensya yung prosecution at yung defense. Letter B, sabi niya, stipulation of facts. Lilinawin lang yung mga facts ng kaso. Ano ba yung mga facts na nagpapatotoo sa kaso? Letter C, i-mark nila yung mga ebidensya gagamitin, mga exhibits. Letter D, waiver of objections to admissibility of evidence. Kunwari, birth certificate nung akusado. O hindi naman na kailangang i-objectionan pa yun. Katunayan nga yun ng pagkatao ng akusado. Kunwari, hindi na ino-objectionan, hindi na mag-object yung depensa ron. So, waiver of objections. Letter E, modification of the order of trial. Kung paano i-conduct yung pagbibista o yung trial. Kung yung akusado raw ay umamin doon sa isinampang kaso sa kanya, doon sa pag-aakusa sa kanya, pero nagpasok naman siya ng isang lawful na depensa. And letter F, such other matters na mapapabilis at magiging patas yung paglilitis. At yung civil, mapapag-usapan yung civil aspects ng kaso. Di ba napag-usapan natin last time na kapag may kasong kriminal, lagi itong may kaakibat na civil aspect. Lagi ka may danyos na kailangan bayaran in layman's terms. Terms. Section 2, pre-trial agreement. All agreements or admissions made or entered during the pre-trial conference shall be reduced in writing and signed by the accused and counsel. Otherwise, they cannot be used against the accused. The agreements covering the matters referred to in Section 1 of this rule shall be approved by the court. Section 3, non-appearance at pre-trial conference. If the counsel for the accused or the prosecutor does not appear at the pre-trial conference and does not offer an acceptable excuse for his lack of cooperation, the court may impose proper sanctions or penalties. Pwedeng parusahan si prosecutor. Bakit ka absent? Napakahalaga nito. Section 4, pre-trial order. After the pre-trial conference, the court shall issue an order, maglalabas ng order, yung korte, reciting the actions taken, the facts stipulated, and evidence marked. Itong order na inilabas ng korte na ito shall bind the parties, limit the trial to matters not disposed of, and control the course of the action during the trial unless modified by the court to prevent manifest injustice. So, yun yung dahilan ng pre-trial. Kinokontrol nito. Yung mga nililimitahan nito. Para kung ano lang yung mahalaga, yun lang ang itatry. Yun lang ang pag-uusapan sa korte. Hindi natin isasali yung mga hindi naman relevant. Rule 119, yung trial. Section 1, time to prepare for trial. After a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial. The trial shall commence within 30 days from receipt of the pre-trial order. Malinaw to ha. Yung trial daw magpapatuloy matapos matanggap ng mga partidos yung order ng pre-trial. Okay. Section 2. Continuous trial until terminated at yung postponements. Trial once commenced shall continue from day to day as far as practicable until terminated o until matapos. Kasi sineset ng korte yung termination, nakalagay na yata sa pre-trial order na ito yung date na magpapresenta kayo ng ebidensya, ganyan. It may be postponed for a reasonable period of time for good cause. For good cause only ha. The court shall, after consultation with the prosecutor and defense counsel, set the case for continuous trial on a weekly or other short-term trial calendar at the earliest possible time so as to ensure speedy trial. In no case shall the entire trial period exceed 180 days from the first day of trial, except as otherwise authorized by the Supreme Court. So, 180 days lang pala yung maximum daw ng trial. So, that is 3, 6, 9, 12, 15, 18, 6 na buwan sa isang criminal case. Tapos, pag submitted for decision na siya, plus 90 days. Parang ganun yata. A time limitations provided under this section and the preceding section shall not apply where special laws or circulars of the Supreme Court provide for a shorter period of trial. So, sa mga nagtatanong po sa akin kung may kaso akong ganito, gaano ba ako katagal lilitisin? Usually, yun po ang sagot. Dapat within the period of 6 months, sabihin mo na 7 months kasama ng desisyon. Kaya lang, hindi po yun nangyayari sapagkat baka naman yung abogado mo o yung abogado ng kalaban merong lawful cause kung bakit nade-delay o ba't hindi sila nakakapag-attend. Kaya humahaba yung kaso. Hindi lang naman dahil sa panloloko ng abogado, napakarami rin namang abogado na may personal na pinagdaraanan kung bakit nade-delay at bakit pinagbibigyan ng korte na ma-delay yung paglilitis. Section 3, exclusions. The following periods of delay shall be excluded in computing the time within which trial must commence. Letter A. Any period of delay resulting from other proceedings concerning the accused, including but not limited to the following. Number 1, delay resulting from an examination of the physical and mental condition of the accused. Number 2, delay resulting from proceedings with respect to other criminal charges against the accused. May iba pa siyang kaso, so hindi ito i-compute as delay. Letter 3, resulting from extraordinary remedies against interlocutory orders. Number 4, delay resulting from pre-trial proceedings, provided that the delay does not exceed 30 days. Number 5, delay resulting from orders of inhibition or proceedings relating to change of venue of cases or transfer transfer from other courts. Letter 6, delay resulting from a finding of the existence of a prejudicial question. And number 7, delay reasonably attributed to any period not exceeding 30 days during which any proceeding concerning the accused is actually under advisement. Yun yung letter A, yun yung mga period ng delay na hindi isasali sa pagko-compute ng time within which trial must commence. Ito yung mga pinahihintulutang delay. And letter B, any period of delay na nagre-resulta or resulting from the absence or unavailability of essential witness. Mahalagang witness yun eh. Diba? For purposes of this subparagraph, an essential witness shall be considered absent when his whereabouts are unknown or his whereabouts cannot be determined by due diligence. He shall be considered unavailable whenever his whereabouts are known but his presence for trial cannot be obtained by due diligence. Meron pa palang letter C. Marami pala to. Letter C. Any period daw ng delay resulting from the mental incompetence or physical inability of the accused to stand trial. Letter D. Valid naman kasi yun. Letter D. If the information is dismissed upon motion of the prosecution and thereafter a charge is filed against the accused for the same offense, any period of delay from the date the charge was dismissed to the date that time limitation would commence to run as to the subsequent charge had there been no previous charge. Walang D. Letter E. A reasonable period of delay when the accused is joined for trial with the co-accused over whom the court has not acquired jurisdiction or as to whom the time for trial has not run and no motion for separate trial has been granted. Letter F. Any period of delay resulting from a continuance granted by any court motu proprio or on motion of either the accused or his counsel or the prosecution, if the court granted the continuance on the basis of its findings set forth in the order that the ends of justice served by taking such action outweigh the best interest of the public and the accused in a speedy trial. Punta tayo sa section 4. So, yung binasa natin, yun yung mga sabihin na natin in layman's term na justify yung delay. Section 4, factors for granting continuance. Ano ba yung continuance na ito? Letter A. Whether or not the failure to grant a continuance in the proceeding would likely make a continuation of such proceeding impossible or result in a miscarriage of justice. And letter B, whether or not the case taken as a whole is so novel, unusual, and complex due to the number of accused or the nature of the prosecution, or that it is unreasonable to expect adequate preparation within the periods of time established therein. Bilang karagdagan daw, in addition, no continuance under Section 3F of this rule shall be granted because of the congestion of the court's calendar or lack of diligent preparation or failure to obtain available witnesses on the part of the prosecutor. Ano ba yung continuance na ito muna? Baka lang may definition tayo mahanap na mas maintindihan natin. Ito. O ito para sa ating kaalaman, continuance. Ang ibig niyang sabihin, the adjournment or postponement of an action pending in a court to a later date of the same or another session of the court granted by a court in response to a motion made by a party to a lawsuit. The entry into the trial record of the adjournment of a case for the purpose of formally evidencing it. So yun po ang continuance, malinaw na sa kaalaman natin. Kaya kaya yung mga nagdaang binasa natin, doon pinapayagan ang continuance o yung adjournment o yung temporary na pagtigil o yung delay sa kaso. Tungo na tayo section 5. Time limit following an order for new trial. If the accused is to be tried again pursuant to an order for a new trial, the trial shall commence within 30 days from notice of the order, provided that if the period becomes impractical due to unavailability of witnesses and other factors, the court may extend it but not to exceed 180 days from notice of said order for new trial. Extended time limit. Sabi rito, notwithstanding the provisions of Section 1G, Rule 116 in the preceding Section 1, for the first 12 calendar month period following its effectivity on September 15, 1998, the time limit with respect to the period from arraignment to trial imposed by said provision shall be 180 days. For the second 12 month period, the limit shall be 120 days, and for the third 12-month period, the time limit shall be 80 days. Ito naman, nakasaad pala dito ang duties ng PAW o ng public attorneys. If the public attorney assigned to defend the person charged with the crime knows that the latter is prevently detained, either because he is charged with a bailable crime o yung naakusahan siya sa isang krimen na pwedeng piyansahan but has no means to post bail, or is charged with a non-bailable crime, or is serving a term of imprisonment in any penal institution, ito yung magiging duty ng public attorney. Letter A, shall promptly undertake to obtain the presence of the prisoner for trial or cause a notice to be served on the person having custody of the prisoner, requiring such person to so advise the prisoner of his right to demand trial. Letter B. Upon receipt of that notice, the custodian of the prisoner shall promptly advise the prisoner of the charge and of his right to demand trial. Kasi karapatan po ng isang akusado na dinggin, di ba? Nakaangkla yan sa konstitusyon. If at any time thereafter the prisoner informs his custodian that he demands such trial, the latter shall cause notice to that effect to send promptly to the public attorney. So dapat yung mga custodian, yung mga BJMP o yung kung sino mang may custody sa mga prisoner, dapat i-inform nila yung public attorney. Letter C. Meron po tayong akusado rito under our custody. Dinidemand niya na siya ay dinggin. Magbibigay ng notice na ganun dapat yung mga custodian sa public attorney. Letter C. Upon receipt of such notice, the public attorney shall promptly seek to obtain the presence of the prisoner in trial. O dapat naman kasi sa pagbibista, present o naroroon yung akusado. Letter D. When the custodian of the prisoner receives from the public attorney a properly supported request for the availability of the prisoner for purposes of trial, the prisoner shall be made available accordingly. Tungo tayo Section 8, Sanctions. In any case in which private counsel for the accused, the public attorney or the prosecutor, letter A, knowingly allows the case to be set for trial without disclosing that a necessary witness would be unavailable for trial. Nako, bawal yun. Kasalanan ito ng isang PAW lawyer, ng isang private counsel o ng isang prosecutor. Letter B, files a motion solely for delay which he knows is totally frivolous and without merit. Oo, nag-file ka ng motion para suriin ng korte na ang layunin mo lang ay mang delay o talagang walang kakwenta-kwenta. Letter C, makes a statement for the purpose of obtaining continuance which he knows to be false and which is material to the granting of a continuance. O naghihingi ka ng continuance, yung binasa natin kanina na ma-adjourn o Ma-delay. Nagsabi ka na may valid ground. Wala naman pala. Letter D. Willfully fails to proceed to trial without justification consistent with the provisions hereof. The court may punish such counsel, attorney, or prosecution as follows. Ito yung kaparusahan nila. By imposing on a counsel privately retained in connection with the defense of an accused a fine not exceeding 20,000 pesos. Number 2. By imposing on any appointed counsel, the official, public attorney, or prosecutor a fine not exceeding 5,000 pesos. And number 3, baka mas mataas na itong mga to ngayon. By denying any defense counsel or prosecutor the right to practice before the court, trying the case for a period not exceeding 30 days. The punishment provided for by this section shall be without prejudice to any appropriate criminal action or other sanction authorized under these rules. So, maaari pang kasuhan ng criminal action or other sanction yung mga magkakamaling attorneys, no? Section 9, remedy where accused is not brought to trial within the time limit. If the accused is not brought to trial within the time limit required by Section 1G, Rule 116, and Section 1 as extended by Section 6 of this rule, the information may be dismissed on motion of the accused on the ground of denial of his right of speedy trial. The accused shall have the burden of proving the motion, but the prosecution shall have the burden of going forward with the evidence to establish the exclusion of time under Section 3 of this rule. The dismissal thou shall be subject to the rules on double jeopardy. Failure of the accused to move for dismissal prior to trial shall constitute a waiver of the right to dismiss under this section. Okay. Okay. Section 10. Law on speedy trial not a bar to provision on speedy trial in the Constitution. Ibig sabihin, sinusunod natin yung Constitution. Yung batas natin para sa speedy trial, hindi nito binabar o hindi nito hinaharangan yung provision ng speedy trial na nakasaad sa Constitution. Actually, nakaangkla nga ito dun eh. Sabi rito, wala raw provision ng batas on speedy trial and no rule implementing the same shall be interpreted as a bar. Ayun. Section 11, Order of Trial. Ito yung order ng trial, no? The trial shall proceed in the following order. Letter A, the prosecution shall present evidence to prove the charge and in the proper case of civil liability. Ito na yung alam nating trial o hearing. Letter B, the accused may, natapos naman si prosecution, the accused may present evidence to prove his defense and damages, if any, arising from the issuance of a provisional remedy in the case. Letter C, the prosecution and the defense may, in that order, present rebuttal. So, kunwari, nag-present na yung depensa, pwedeng kontrahin ito, magpresenta ng pangontrang ebidensya si prosecution, pwede na naman mag-sub-rebuttal naman si defense. Yun na ibig sabihin nun. Unless the court, in furtherance of justice, permits them to present additional evidence bearing upon the main issue. Letter D. Upon admission of the evidence of the parties, the case shall be deemed submitted for decision unless the court directs them to argue orally or to submit written memoranda. Minsan, pag natapos na, pag nakita mo, the prosecution rests, the defense rests, bago solusyonan o bago desisyonan yun, sasabihin pa muna ng korte minsan na we are, both the prosecution and the defense is required to submit their written memoranda. Ayun, mas komprehensibo. Naguluhan ako sa inyo dito, ito na nga lang, pagbasihan ko na nga lang to. Parang ganoon. Section 12, application for examination of witness for accused before trial. Ito, before trial naman to. When the accused has been held to answer for an offense, he may, upon motion with notice to the other parties, have witnesses conditionally examined in his behalf. At ito yung ilalaman ng motion. The motion shall state, letter A, the name and residence of the witnesses. Letter B, the substance of his testimony. Letter C, that the witness is sick or infirm as to afford reasonable ground for believing that he will not be able to attend the trial or resides more than 100 kilometers from the place of trial and has no means to attend the same, or that the other similar circumstances exist that would make him unavailable or prevent him from attending the trial. The motion shall be supported by an affidavit of the accused and such other evidence as the court may require. Section 13. Examination of defense. Examination of defense witness at papaano raw ginagawa. If the court is satisfied that the examination of a witness for the accused is necessary, an order will be made directing the witnesses be examined at a specified date, time, and place, and that a copy of the order be served on the prosecutor at least 3 days before the scheduled examination. The examination shall be taken before a judge, or if not practicable, a member of the bar in good standing so designated by the judge in the order, or if the order be made by a court of superior jurisdiction before an inferior court to be designated therein, period. The examination shall proceed notwithstanding the absence of the prosecutor, provided he was duly notified of the hearing. A written record of the testimony shall be taken. Ito yung may mga stenographer na isusulat nila kung ano yung nangyari dun sa hearing. Section 4, bail to secure appearance of material witness. When the court is satisfied upon proof or oath that a material witness will not testify when required, it may, upon motion of either party, order the witness to post bail in such sum as may be deemed proper. Upon refusal to post bail, the court shall commit him to prison until he complies or is legally discharged after his testimony has been taken. Section 15. Examination of witness for the prosecution. When it satisfactorily appears that the witness for the prosecution is too sick or infirm to appear at the trial as directed by the order of the court, or has to leave the Philippines with no definite date of returning, he may forthwith be conditionally examined before the court where the case is pending. Such examination in the presence of the accused or in his absence after reasonable notice to attend the examination has been served on him shall be conducted in the same manner as an examination at the trial. Failure or refusal of the accused to attend the examination after notice shall be considered a waiver. The statement taken may be admitted in behalf of or against the accused. Tungo na tayo Section 16, Trial of Several Accused. When two or more accused are jointly charged with an offense, they shall be tried jointly unless the court, in its discretion and upon motion of the prosecutor or any accused, orders separate trial for one or more accused. Tungo naman tayo Section 17, Discharge of Accused to be State Witness. Ito, madalas ito napapanood sa TV, yung mga kasali sila sa kalokohan pero sila yung whistleblower o sila yung state witness. When two or more persons are jointly charged with the commission of any offense upon motion of the prosecution before resting its case, the court may direct one or more of the accused to be discharged with their consent so that they may be witnesses for the state when, after requiring the prosecution to present evidence and that the sworn statement of each proposed state witness at a hearing in support of the discharge, the court is satisfied that. Pero bago nating basahin ito mga ito, paliwanag lang natin na yung state witness po, in-applyan niya yan na siya ay maging witness at nakita ng korte na kailangan siya para sa makuha natin ang buong hustisya, no? Kapag nasatisfy yung korte na letter A, there is absolute necessity for the testimony of the accused whose discharge is request. Ulitin ko lamang, with consent of the accused. Kunwari, inaakusahan nyo si A to Z, meron silang krimen. Etong si A gusto niya maging state witness, meron consent niya. O, na maging state witness siya. Ayun, gagawin siyang state witness. Okay? Kung, yun na nga, yung letter A, mahalaga ang kanyang testimonya, at siya ay discharge, okay? Ni-request, basahin na lang natin. Letter A, there is absolute necessity for the testimony of the accused whose discharge is requested. Letter B, there is no other direct evidence available for the proper prosecution of the offense committed except the testimony of the said accused. Letter C, the testimony of said accused can be substantially corroborated in its material points. May punto talaga at siguradong alinsunod o magtutugma sa ibang mga ebidensya. Letter D, Said accused does not appear to be the most guilty. O, di ba? Mahalaga yan, ha? Hindi siya yung ulo ng snake. And letter E, said accused has not at any time been convicted of any offense involving moral turpitude. O muli, basahin natin ang mga moral turpitude na yan. Ano ba yan? Moral turpitude crimes. Basahin natin. Para lang mas maintindihan natin. Basta ito yung mga crimes na mukha siyang manloloko. Alam mo yun, talagang nanlilin lang ito. Hindi pa siya nakakasuhan ng moral turpitude. Sandali. Ba't ang Wikipedia na ito? Okay. Linawin na lang natin. Hindi pa siya nakasuhan ng mga kasong described as an act of baseness, vileness, or depravity in the private and social duties which a man owes to his fellow men or to society in general, contrary to the accepted and customary rule of right and duty between a man and a man. So, kunwari, hindi siya nakasuhan sa pagiging, kunwari, pulis siya, tapos hinayaan niya lang mamatay yung isang tao. Yan, o kaya sa Pilipinas, yung crime ng adultery. Nakikiapid siya, di ba? Yan, alam ko nabasa na natin ito sa ibang natin sa ibang live natin Basta yung gano'n, para at least alam nyo lang yung yung ibig sabihin na hindi pa na-convict itong akusadong ito ng mga offense involving moral turpitude. Evidence adduced in support of the discharge shall automatically form part of the trial. If the court denies the motion for discharge of the accused as state witness, his sworn statement shall be inadmissible in evidence. So, kunwari, sinasabi ng prosecutor, judge, alisin na natin to, gawin nating witness. Lalakarin ko yung pagiging witness niya. Kaso dininay ng korte ito. Yung kung anumang sinabi nung akusadong yon na nag-a-apply as state witness ay hindi na hindi na siya magiging admissible o hindi na siya tatanggapin bilang ebidensya. Section 18, discharge of accused operates as acquittal. Okay? So the order indicated in the preceding section shall amount to an acquittal. So kung pinayagan siya maging state witness, ang katumbas nun ay acquittal of the discharged accused and shall be a bar. Haharangan na, hindi mo na siya pwedeng, it shall be a bar to a future prosecution for the same offense unless the accused fails or refuses to testify against his co-accused in accordance with his sworn statement constituting the basis for the discharge. Siyempre, ang basihan mo para pakawalan ka o palayain ka dahil magbibigay ka ng mahalagang testimonya para sa kaso. Tapos di mo ginawa. So, kulong ka ulit. O pwede kang akusado ka ulit. At pag ginawa mo to, patay ka. Sigurado. Inunsi mo yung mga kasama mo Section 9. When mistake has been made in charging the proper offense. When it becomes manifest at any time before judgment that a mistake has been made in charging the proper offense and the accused cannot be convicted of the offense charged or any other offense necessarily included therein, the accused shall not be discharged if there appears good cause to detain him. In such case, the court shall commit the accused to answer for the proper offense and dismiss the original case upon the filing of the information. Section 20, appointment of acting prosecutor. When a prosecutor, his assistant, or deputy is disqualified to act due to any of the grounds stated in Section 1 of Rule 137 or for any other reasons, the judge or the prosecutor shall communicate with the Secretary of Justice in order that the latter may appoint an acting prosecutor. Section 21. Exclusion of the public. The judge may motu proprio exclude the public from the courtroom if the evidence to be produced during the trial is offensive to decency or public morals. Ayan, yung mga nagwa-what the fuck, yung mga mga you have no morals, di ba? He may also, on motion of the accused, exclude the public from the trial except court personnel and the counsel of the parties. Sabi nga nila, If you have nothing good to say, don't say it at all. Get the fuck out of here, di ba? Yan sinasabi nila. Section 22. Consolidation of trials of related offenses. Charges for offenses founded on the same facts or forming part of a series of offenses of similar character may be tried jointly at the discretion of the court. Okay? Pwedeng bistahin o dinggin sabay-sabay. Okay? Yung mga related offenses ng korte. Section 23, demurrer to evidence. After the prosecution rests its case, the court may dismiss the action on the ground of insufficiency of evidence. Number 1, on its own initiative after giving the prosecution the opportunity to be heard, or number 2, upon demurrer to evidence filed by the accused with or without leave of court. If the court denies the demurrer to evidence filed with leave of court, the accused may adduce evidence in his defense. When the demurrer to evidence is filed without leave of court, the accused waives the right to present evidence and submits the case for judgment on the basis of the evidence for the prosecution. The motion for leave of court to file demurrer to evidence shall specifically state in its grounds and shall be filed within a non-extensible period of 5 days after the prosecution rests its case. The prosecution may oppose the motion within a non-extendible period of 5 days from its receipt. Diba? Ito yung sa tingin ng depensa. Hindi ko na kailangan depensahan to. Hindi sapat. Hindi niya napatunayan sa kanyang presentation na na dapat i-convict itong taong ito. File na lang siya ng demurrer to evidence. If leave of court is granted, the accused shall file the demurrer to evidence within an extendable period of 10 days from notice. The prosecution may oppose the demurrer to evidence within a similar period from its receipt. The order denying the motion for leave of court to file demurrer to evidence or the demurrer itself shall not be reviewable by appeal or by certiorari before judgment. So yung isang defense lawyer na nag-file ng demurrer na deny ito, hindi siya pwede mag-apila by certiorari bago yung judgment. Section 24. Reopening. At any time before finality of the judgment of conviction, the judge may motu proprio or upon motion with hearing in either case reopen the proceedings to avoid a miscarriage of justice. The proceedings shall be terminated within 30 days from the order granting it. Punta na tayo sa Rule 120, yung judgment. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition on him of the proper penalty and civil liability kung meron man, if any. It must be written in the official language, personally and directly prepared by the judge and signed by him, and shall contain clearly and distinctly a statement of the facts and law upon which it is based. Sana nga taglish ang judgment, no, para mas maintindihan ng akusado at ng mga partidos. Ano yung nilalaman or contents of judgment? If the judgment is of conviction, it shall state, number 1, the legal qualification of the offense constituted by the acts committed by the accused and the aggravating or mitigating circumstances which attend its commission. So, pinalala ba nito o medyo binawasan ba? Meron bang mga circumstansya na pinalala yung krimen? Example po niya, kunwari, isa kang kasambahay. Nagnakaw ka. Pinalala ng pagiging kasambahay mo yung pagnanakaw mo dun sa amo mo sapagkat pinagkakatiwalaan ka tapos biglang ninakawan mo siya. So, aggravating yon. O mitigating naman, hindi naman ganun kalala. Merong mga elemento na bumabalot dyan na yung dapat na krimen mo ay ibinababa yung penalty sapagkat may mga ginawa ka naman na hindi naman ganun kasama. Number 2, the participation of the accused in the offense, whether as principal, accomplice, or accessory after the fact. Number 3, the penalty imposed upon the accused. And number 4, the civil liability or damages caused by his wrongful act or omission to be recovered from the accused by the offended party, if there is any, unless the enforcement of the civil liability by a separate civil action has been reserved or waived. In case naman the judgment is acquittal o napawalang sala siya. It shall state whether the evidence of the prosecution absolutely failed to prove the guilt of the accused or merely failed to prove his guilt beyond reasonable doubt. In either case, the judgment shall determine if the act or omission from which the civil liability might arise did not exist. Section 3. Judgment for two or more offenses. When two or more offenses are charged in a single complaint or information but the accused fails to object to it before trial, the court may convict him of as many offenses as are charged and proved and impose on him the penalty for each offense, setting out separately the findings of fact and law in each offense. Section 4. Judgment in case of variance between allegation and proof. When there is variance between the offense charged in the complaint or information and that proved, and the offense as charged is included in or necessarily includes the offense proved, the accused shall be convicted of the offense proved which is included in the offense charged or of the offense charged which is included in the offense proved. Okay, medyo magulo yun ha. Ibig lang sabihin nun, kung may pagkakaiba doon sa iniakusa at iba yung napatunayan, kung ano yung napatunayan, yon, the accused shall be convicted of the offense proved. Yon. Section 5. When an offense includes or is included in another. An offense charged necessarily includes the offense proved when some of the essential elements or ingredients of the former as alleged in the complaint or information constitute the latter. And an offense charged is necessarily included in the offense proved when the essential ingredients of the former constitute or form a part of those constituting the latter. Section 6. Promulgation of judgment. Ito na yung binabasa ng hukuman na ikaw, Francisco Faro, ay hinahatulang guilty sa pambabastos. Yun. Or ikaw, Mom's Wrench Kitchen, you are judged to be, you are acquitted. O, kunwari, ganon. So, the judgment is promulgated by reading it in the presence of the accused and any judge of the court in which it was rendered. However, if the conviction is for a light offense, the judgment may be pronounced in the presence of his counsel or representative. When the judge is absent or outside of the province or city, the judgment may be promulgated by the clerk of court. If the accused is confined or detained in another province or city, the judgment may be promulgated by the executive judge of the regional trial court having jurisdiction over the place of confinement or detention upon request of the court which rendered the judgment. The court promulgating the judgment shall have authority to accept the notice of appeal and to approve the bail bond pending appeal, provided that if the decision of the trial court convicting the accused changed the name of the offense from non-bailable to bailable, the application for bail can only be filed and resolved by the appellate court. Ayan, may provision na tayong nabasa, ganyan na ganyan. The proper clerk of court shall give notice to the accused personally or through his bondsman or warden and counsel requiring him to be present at the promulgation of the decision. O kung nakakulong man yung tao o kung siya man ay temporarily nakalaya, i-require yung BJMP or police or yung bondsman niya na kailangan naroon siya at the time of the promulgation of the decision. If the accused tried in absentia because he jumped bail or escaped from prison, kunwari tumakas siya sa preso o lumaya siya tapos hindi siya nagpakita, nag-trial siya in absentia, the notice to him shall be served at his last known address. In case the accused fails to appear at the scheduled date of promulgation of judgment despite notice, the promulgation shall be made by recording the judgment in the criminal docket and serving him a copy thereof at his last known address or through his counsel. If the judgment is for conviction and the failure of the accused to appear was without justifiable cause, he shall lose the remedies available in these rules against the judgment, and the court shall order his arrest. Okay, kung napatunayan ka nagbabastos, if you are disrespectful, and if you're a criminal, the court shall order your arrest. Within 15 days from promulgation of judgment, however, the accused may surrender and file a motion for leave of court to avail of these remedies. He shall state the reasons for his absence at the scheduled promulgation, and if he proves that his absence was for a justifiable cause, he shall be allowed to avail of said remedies within 15 days from notice. So, pwede naman siyang mag-file ng motion with leave of court para ipresenta niya sa korte kung bakit siya absent. Baka naman valid yung dahilan, nagkasakit, hindi makakilos, or may bagyo, binaha ang daan, ganyan. Section 7, Modification of Judgment. A judgment of conviction may, upon motion of the accused, be modified or set aside before it becomes final or before appeal is perfected. Except where the death penalty is imposed. As of this time, there is no death penalty in this country. A judgment becomes a final order, or a judgment becomes final after the lapse of the period for perfecting an appeal, or when the sentence has been partially or totally satisfied or served, or when the accused has waived in writing his right to appeal or has applied for probation. Tungo na tayo Section 8, Entry of Judgment. After a judgment has become final, it shall be entered in accordance with Rule 36. Section 9, Existing provisions governing suspension of sentence, probation, and parole not affected by this rule. Sinasabi niya lang that nothing in this rule shall affect any existing provisions in the laws governing suspension of sentence, probation, or parole. Tungo na tayo sa Rule 121, New Trial or Reconsideration. At any time before a judgment of conviction becomes final, the court may, on motion of the accused or at its own instance but with the consent of the accused, grant a new trial or reconsideration. What are the grounds for a new trial? Letter A, the errors of law or irregularities prejudicial to the substantial rights of the accused have been committed during trial. Letter B, the new and material evidence has been disclosed which the accused could not with reasonable diligence have discovered and produced at the trial, and which, if introduced and admitted, would probably change the judgment. Section 3. What are the grounds for reconsideration? The court shall grant reconsideration on the ground of errors of law or fact in judgment which requires no further proceedings. Section 4. Form of motion and notice to the prosecutor. The motion for a new trial or reconsideration shall be in writing and shall state the grounds on which it is based. If based on a newly discovered evidence, the motion must be supported by affidavits of witnesses by whom such evidence is expected to be given or by duly authenticated copies of documents which are proposed to be introduced in evidence. Notice of the motion for new trial or consideration shall be given to the prosecutor. Section 5. Hearing on motion. Where a motion for a new trial calls for resolution of any question of fact, the court may hear evidence thereon by affidavits or otherwise. Section 6. Effects of granting a new trial or reconsideration. Letter A. When a new trial is granted on the ground of errors of law or irregularities committed during the trial, all proceedings and the evidence affected thereby shall be set aside and taken anew. The court may, in the interest of justice, allow the introduction of additional evidence. Letter B. When a new trial is granted on the ground of newly discovered evidence, the evidence already adduced shall stand, and the newly discovered and such other evidence as the court may, in the interest of justice, allow to be introduced shall be taken and considered together with the evidence already in record. And letter C. In all cases when the court grants new trial or reconsideration, the original judgment shall be set aside or vacated and a new judgment rendered accordingly. So, next time, tatapusin na natin yung buong criminal procedure. Ngayon, natapos natin ang Rule 116 to 121. Ang buong criminal procedure po ay Rule 1110 hanggang 127 sa ating Rules of Court. Sana po ay may natutunan tayo ng konti at sana po ay meron ako na ipaliwanag ng tama in layman's term. Muli, ito po si Lolo Ray. Maraming salamat po and God bless.